3, 2, 1.
Honorable members, our guest speaker, colleagues, welcome to our 30th Virtual Leadership Seminar. Today being our 30th edition is actually worth celebrating. It means we have done this seminar and today is the 30th time we are holding it. Let's start with a short word of prayer. Father Lord, we thank you for this day. As we have gathered here to impact knowledge on legislation, we ask for your guidance, blessings, and wisdom, and we call for our guest speaker to also be impacted so that he can also share with us and make us better than we are in legislation and the specialty of law passage. In the name of God, Amen.
Amen.
Colleagues, I welcome you to the 30th edition of the Virtual Leadership Seminar under Youth Impact Movement. I am John Samega Shebiglo, your host and Executive Director of Youth Impact Movement. Our guest speaker for today's edition is a very special man. And before I invite him to take the floor, I'm going to give him synopsis about Youth Impact Movement, Youth Impact Parliament, the Virtual Leadership Seminar Series, and also our last sitting that we held on Sunday. Then I'll introduce him and he will speak to us and deliver his seminar. So our guest speaker and our viewers, Youth Impact Movement is a youth-led organization, voluntary-led organization that is bent and focused on capacity building. We were established in 2021, April, and next year, April, will be 5 years. Youth Impact Parliament is the parliamentary branch of this voluntary organization. The main chapter is in Ghana, and it has two chambers, the upper chamber being the Senate and the lower chamber being the Parliament. We also have other chapters such as Uganda, Kenya, Namibia, and India. We are not just a Ghana group, but a Pan-African group, if you may say. As a youth parliament, we sit once every month, sir, to deliberate, build our capacity, and prepare ourselves for the future. And we are not just a youth parliament, but the most vibrant youth parliament in the entire of Ghana. We have visited Parliament a couple of times, and next year we'll be coming again. The Virtual Leadership Seminar is a seminar that is focused on bringing resource people to speak with us. And, due to technology, we are able to bridge the gap of distance. We are able to sit in the comfort of our homes and still hold very impactful seminars. We held the first seminar in January 2022. Was it January or February? I think the 20th of January or February in 2022. And our guest speaker, it amazes you that our first edition, we had Honorable Eric Edem Admana as our guest speaker. Yes. As of then, he wasn't an MP. And we had him as our first guest speaker for this edition. We have also had Honorable Peter Nochukote, who is currently the chairman for the Parliament Education Committee and the Member of Parliament for Akachi North as well. We have had different people, Honorable Eric Belly. We have also had the current Marshal of Parliament, whose name has skipped me a little bit, but he also spoke to us on one of our editions, and he spoke clearly on securities and how security details are handled in Parliament, explaining about the maze and stuffs. We have had so many. But may I say that your topic is one that we have not exactly had yet, because it's talking about the mastery of parliamentary language, practice, and procedure, which is to say that your lecture is not a repetition, but it is basically a focus area that we are coming to delve in. Our guest speaker, may I say that on the 14th of December 2025 at Ho, Youth Impact Parliament held a joint sitting of the Senate and the Parliament to pass our first bill, a bill that is drafted on one of our initiatives, which is basically to promote women leadership in the entire group. The bill was drafted with a template on one of the bills passed by Parliament of Ghana, and we have gone through the steps, and we are very happy that we have done this, because members here can attest to the fact that we have been able to have a feel of what happens in Parliament. But I can tell that most of our colleagues who were present there did not really understand the reasoning of some of these procedures, and which makes value for this particular seminar we'll be holding with you, sir. And we are hoping that from your seminar, you would have explained to us what exactly we did on Sunday, the 14th of December. So that is just a synopsis on our entire initiative. And I will now go ahead to introduce our guest speaker to us. And after the introduction, you have the opportunity to now interact with us. Colleagues, our guest speaker is a legal author, and he is also a distinguished Ghanaian lawyer. He is also a parliamentary professional with extensive experience in legal research, legislative process, and statutory interpretation. Over the course of his career in the Parliamentary Service of Ghana, he has provided expert support to parliamentary committees, contributed to the refinement of bills and subsidiary legislation, and advised members of parliament on procedures, drafting, and constitutional compliance. Colleagues, our guest speaker is also an author of 3 notable books that have contributed significantly to the public legal education and Ghana's legislative practice. They are Reading the Law, The Citizen's Guide, and Principles, Practice, and Procedures. Colleagues, our guest speaker's expertise spans over legal writing, legislative drafting, judicial language, governance processes, and parliamentary administration. His works and professional practice demonstrate a unique ability to simplify complex legal concepts whilst maintaining analytical rigor and doctrinal accuracy. And I must say that this particular seminar that he's doing for us, he's doing it out of love for us, having seen that we are a youth group who are hungry to learn. Because as a matter of fact, he should be charging us like $300 by now. But I know that he's doing this as one of his Christmas gifts to the youth groups, because he has facilitated very big conferences in legal writing and then all those. So, honourable members, if I want to continue, I might end up delivering the lecture myself. So I want to end the introduction here, because I'm sure in his delivery we would get to know more about him and learn a lot from him. Honourable members, our guest speaker is no commoner but a unique asset to Parliament of Ghana, who has made time for us as a youth group for us to learn. I want to call on members to listen carefully, attentively, and after his presentation, will be allowed to ask questions. Honourable members, with all due respect, I want to, on this point in time, call on our guest speaker to address the session. Our guest speaker, your participants, your guest speaker. Thank you very much.
Thank you very much, Mr. President, and a very good evening to our colleagues. I call you colleagues because we may be peers, but forgetting all protocols, I will address you as the president and members, honorable members of your parliament. I mean, parliament as a generic term, so forgive me if I use parliament throughout. Okay, it's a wonderful opportunity to be with you. Yes, and thank you for reading that long profile. It said that India Amin's profile was too long that by the time they were done reading it, his tenure had come to an end. So I'm happy that mine did not take us that far. Yes, but all in all, thank you very much. And thank you also for the quick introduction about what you stand for and then the necessity for this particular session. Thank you very much. So we're here to discuss parliamentary language, practice and procedure. Very fundamental, but very, very important. You see that language is very, very important device through which a lot of things can be done. And that language must be understood as a fundamental element for you to have any fruitful or productive discourse. So parliamentary language is a technical language. You will find that various fields have technical language, meaning that this set of words that are used that are different from what is known in the English language or the grammatical meanings of words. Okay, so it means that you need to take some time and make effort to understand that technical, language so that you can properly engage. And you are in a forum of mimicking parliament. And of course, so the language that you should adopt for your proceedings is that of the parliamentary language. And so my book comes in handy for your use. So today we're going to learn more about the rationale for doing the things that you see Parliament doing, for which you have been modeling. Okay. So yes, so I will just take my time and take you through the basics. Okay, so I have spoken about parliamentary language. Just a while ago, I had some new service persons in my office, and I was taking through them how even parliamentary business is arranged or structured. That you have one parliament having a 4-year duration. This 4-year duration, called a term of parliament, 113, or the Constitution defines that. The parliament shall, last for 4 years, beginning from the first sitting, the first day it sits. Okay, so you have a term of our parliament, unlike your bicameral parliament. Ours is unicameral parliament. And so that 4-year term, within the 4-year term, parliamentary business is structured into sessions. So you have first session, second session, third session, and fourth session, which will end it. Okay, and within a session, which I always liken to, let's say, a term in our secondary school cycle. For those who are in Ghana, then you pick an academic year at the secondary senior high school level. You will have one academic year consisting of 3 terms. So one academic year is equivalent to a session. Yeah, a period of 12 months within which Parliament organizes its business. So you have academic year, you can put side by side with a session of Parliament, And within a session of Parliament, you have a period within which Parliament sits continuously over a period. That is called a meeting of Parliament, as distinguished from a sitting of Parliament, which is the daily meeting. So the meeting of Parliament, if I'm not being tautologous, then a meeting of Parliament is a period within which Parliament sits continuously, or Parliament holds sittings continuously over a period until it rises sine die, or until it rises and goes on recess. So rising sine die is also a technical term, back to parliamentary language, which has a very important significance, because a rising sine die that ends a meeting of Parliament. And that is very, very important, because constitutionally, Article 197 of the Constitution talks about, let's say, absenteeism even being a ground for vacation of seats. And so if a member is absent from the sittings, 15 sittings of Parliament in a meeting of Parliament. So you see that constitutionally, meeting has a lot of significance, and in particular this place, so that if someone has been, or a member of Parliament has been absent for years, but not within one meeting of the House, then it means that the rule will not apply. So that is how important these technologies are. Okay, so having understood a meeting of Parliament to be, let's say, a term of, a term in our secondary school calendar. You know, you have the academic year, then you have term 1, term 2, term 3. So in Parliament, you have, let's say, the session being the academic year, and then you have meeting, first meeting, second meeting, third meeting. Okay, and we have said that just as the secondary level, you have a term which is defined by the period in which students will attend lectures continuously until they go on vacation. Parliament 1, a meeting is a period within which Parliament sits continuously until it goes on recess, which we term as rising sine die. Okay, so that about it. And then, of course, so you know about a sitting, which is the daily sessions that are held to transact specified business of the House. Okay, so a lot more, but as for the language, as and when they come about, we'll do that. But the point is that why do we have such language? Because this language is special because it has deeper meaning and implications than what apply in ordinary language. With the concept of even the here, and now I'm sure that your members quite curious, so they will be acquainted with the fact that the correct version of the expression is here, and not here. Here, or, is a borrowed expression from the Westminster system, which has its origin in members expressing, interest in what members say during debate, as, hear him, hear him, hear him. So over time, that hear him, which is pointing or turning the attention of members to focus on what the person is saying, because the person is making very good points. Okay, so it takes attention to the person, and then it puts all attention to quality of debate. And then remember that it's an alternative to clapping. So in Parliament, you don't clap, because if everyone is to clap and political device that you have, then there will be chaos. And the here should even be used in moderation. If not, everybody is saying here, it also creates some disorder. That's why, Speaker, you are there to moderate, reasonably, to achieve decorum at all times. Okay, so these have very important meanings, and that is why they've been held on over a long period and used to achieve certain legal consequences. Recently, what happened, the resumption of this meeting brought into some debate the lapsing or otherwise of the Human Sexual Rights and Ghanaian Family Values Bill, alias the anti-LGBTQ bill, whether it lapsed, or less whether it became void upon the dissolution of the 8th Parliament, or because it was done by the 8th Parliament and it was waiting presidential assent, the president could just go ahead and sign. But the concept in Parliament is about lapsing of bills, lapsing, bills ceasing to have effect or lacking the capacity to be worked on. Okay. And the debate, I had a quick answer to that. My advice to members who approached me was that Article 113 is clear about a duration of Parliament. Article 106, which provides the procedure for passing bills into law, also tells you what this Parliament that is created under Article 93(1) and vested with legislative powers under 93(2) is supposed to do. So you have Parliament is not a continuous institution. Rather, it's a 4-year organic institution. There is a seeming transition, but they stand independent. And then parliamentary records show clearly the difference. That's why every sitting day is marked. I have an example here. It's not for today's or yesterday's sitting, but this is the Thursday, 31st July, earlier this year. And it reads, in the first session of the 9th Parliament of the Fourth Republic of Ghana, votes and proceeding minutes of the 42nd sitting of the second meeting of the 9th Parliament of the Fourth Republic. So it's clearly marked, so you can locate it where it's found. You will find that it becomes so important when there's litigation. But back to the point of the controversies surrounding the lapsing or otherwise of the anti-LGBTQ bill. So Parliament is created to last 4 years. And per Article 106, a bill can only be passed when Parliament has read it 3 times and then it has been transmitted to the President. President has assented it to it. Then that is the only time the process gets completed. And that is Article 106(1), and that is even affirmed by the decision in Richard Sky. Richard Sky, when he sought to even stop Parliament from proceeding to submit or transmit the bill to President for assent. The Supreme Court said that it was premature because it wasn't a law yet. And if you read Article 2, on the basis of which the Supreme Court's jurisdiction was invoked, it says that an act or omission, so whatever you want to challenge should have happened. There should have been a finality to it. Okay, so to the extent that Parliament could not act and pass laws and do other businesses within the 4-year period, the mandate they had, that means that whatever was before that Parliament is erased. It doesn't matter if it was left with a point to be put there. It was not complete. And then it means that it has to die naturally, automatically. And then there's opportunity to resurrect it by the new Parliament. Okay, because then the second even argument is that if the argument is that it can be worked on because Parliament worked on it, so the President could just assent it and it becomes law. What about if the President refuses and wants he want to employ the provisions of the Constitution where he could refuse to assent to a bill? When you send a bill to the President, it's not automatic. The President is given a number of options, one of which is to refuse to assent. But when he refuses, the Constitution further obligates him to get back to Parliament that I'm refusing. And then within a certain period, he has to write back pointing to Parliament where he disagrees and the reasons and all that, and in a memo, a written document. okay, or just inform Parliament that I may refer the bill to the Council of State for determination under Article 90. Okay, so all those options are there and must be explored. But the point is made that once Parliament, which has a 4-year mandate, is unable to act completely on a subject, whatever the subject is, lapses. Okay, so lapsing of bills is also a matter of language, has strong consequences, legal consequences, which must be understood. The concept of sub judice or sub judice, when members matters have gone before the court, to what extent can Parliament deal with that subject while the matter is pending? All these, concepts are there, different practices everywhere. But Ghana, our practice is what we adhere to. And then even to back the lapsing of bills, there are a number of bills that every 4 years we are directed to write to the Attorney General's office to be reintroduced because they have lapsed. So it's not only the anti-LGBTQ one. So if you want to go on the language, then it will take the whole day. So let me move to the practice and procedure, and let's even get to understand why practice and procedure. Why? Parliament is established, or the Constitution establishes Parliament as one of the 3 organs of the state. Our speaker has advised that we don't use organs of government because in Ghana, Constitution defines government not in its main general or broad terms, but in restricted terms to be the body that exercises executive power. So when you say government, then it's like you are subjecting Parliament as an appendage of the executive. So it's better to say an organ of the state rather than organ of government. So I choose to follow that path. Okay. So Parliament has been established as the body made to exercise the legislative powers of Ghana as a sovereign state. The Constitution has made attempt in certain aspects where Parliament is given a mandate specifying the procedure or the steps to follow in exercising the power. So the Constitution has given set of powers to Parliament, some of which are Parliament is playing active role or the main player in there. Others, Parliament is serving as ratificatory or an endorsing or approving body. But in all these powers, so in some cases, the Constitution gives you the steps to follow. But in most of the cases, there are no steps to follow. And clear example is Article 78, talking about the power of the president to appoint ministers of state, majority of whom should be appointed from Parliament, but they should be subjected to prior approval by Parliament. That ends the process. So no step is given to Parliament to follow. That's why Article 110 of the Constitution gives Parliament the power to develop or adopt standard orders to regulate its own procedure. Because the power is given to you, but there must be a way to exercise that power. And that kind of the body of rules, practices, and all that helps Parliament to follow a certain path in exercising its constitutional powers are generally the practice and procedure. The distinction is that procedure, when we say procedure or rules or procedure, or the rules book, then we're talking about the standing orders, which are the written procedural rules of the House. But besides that, there are certain practices that have not, crystallized or developed or have been codified. They have not yet been codified or written in the rules book, but there's some it's part and parcel. It has become part and parcel of how Parliament behaves in its environment. And so some of these, an example is when it comes to subsidiary legislation, which you mentioned, my new book, Subsidiary Legislation in Ghana, Principles, Practice, and Procedure, that there's a pre-laying consideration. I don't want to bore you, but quickly, we've had a number of cases like the primary and Attorney General, where Parliament amended some regulations and it was challenging the Supreme Court. The court said, no, Parliament, you lack the capacity to amend any instrument that is laid under Article 11.7 of the Constitution, because that power is a delegated power. So it's Parliament or the Constitution that has delegated that power. So it is only the maker, which may be a minister or some public other body, that will introduce it. And so Parliament's role is to either allow it to pass or annul it. So these are just the two powers Parliament has when it comes to subsidiary legislation. I'm talking about constitutional instruments, CIs, legislative instruments, LIs, executive instruments, EIs, and bylaws of district assemblies for our decentralized unit. Okay, so Parliament introduced pre-laying discussions or consultation between any institution or minister that wants to introduce a regulation, so that there will be a first opportunity to clean it up, so that Parliament will not have the difficulty of amending it, when it's finally laid. It's when it's laid that you cannot touch it. But prior to that process, you can at least there can be some discussion and some trade-off to, smoothing any rough edge that may be identified. So that is part of it. There are no things that Parliament does that they are not written, but that is why you have, the institutional memories, largely, driven by the clerk to Parliament, feeding the speaker with some of the practices or precedents or, practices of the House that supports whatever is there to deal with issues that come up during debate in the House. So yes, so critically, we said that Parliament is established by the Constitution, and then the Constitution does not provide full rules to regulate how that power is to exercise. So the President procedure provide the detailed rules on how parliamentary powers are to be exercised. So that's one key point. And then also it's helping you to translate, or the practice and procedure, translate the constitutional powers or powers of Parliament into workable instruments. You break it down so that once you go to the process, you exercise it. So like a bill process, you have the right to make laws, and you make laws by passing bills into law. So you define the process, and by the time you finish the process, you will have exercised that power. So that is the beauty of practice and procedure. And it helps you to organize debate so that you can know who can speak at any particular time, and then how long can the person speak, and all those things. Motions, who can introduce motions, how should it be introduced, and all that. How do you deal with disorder in the House? How do you deal with disruption? You remember what happened recently, that the minority insisted that they're not going to move out, but they will insist during the budget consideration stage, they will not move, and they were making noise. Definitely, that is the disorder. Disorder is unpermitted. There are a number of rules, opportunities, tools in Parliament that can be explored to deal with protest or objection to things like that, including walkout press conferences and other things. But for you to hold Parliament hostage and say we will not go back, is clearly an illegality and should not be tolerated anywhere. And that's why the Speaker is giving powers to even order for a person who is behaving disorderly to be removed from the House. But I think in this particular occasion, they were overwhelmed, and the Speaker adopted a more tolerant posture. But they were able to go ahead. But that was not proper. It's not a proper way to deal with that. And practice and procedure also help to protect both majority rights and minority rights. That should be fair, making sure that everybody gets the opportunity to speak. Majority should benefit from its numbers, because decision of the House is based on majoritarian rule. Okay, but you are giving that effect to that to ensure that the majority will have its say. Sorry, the majority will have its way, but the minority will have its say. So yes, that is why we debate motions or engage in debate before any decision is made. Because when you engage in debate, then quality options come out. And that is the whole exercise, because if Parliament would take the decision anyway, why would they spend time debating? So this is where you reflective processes go on. You have to question systems, how they have evolved, and then it dawns on us to write and put these things in perspective. Because when there's a debate, different ideas come out. The truth is supposed to so come out, and at the end of the day, based on the quality of debates, a member may be influenced to change his decision. Okay, so it's a very important process, but you need practice and procedure to regulate who can speak. If the speaker does not catch, or the speaker's eye does not catch you, then you cannot speak. You don't just stand up and then you start. I'm sure that, Mr. Speaker, you have been facing some of these challenges during the sittings of the House. Sometimes I guess heated, and members will just get up and calling you or attempting to speak and all that. That is all not proper. You just rise, and then if the speaker, you should catch the attention or the eye of the speaker, and then you can be called to speak. And the speaker can also say, run up, or your time, to speak is ended. All those are regulated by the scheme. So yes, so you can see the wonderful rationale for having practice and procedure. But beyond all this is the creation of certainty, predictability in how Parliament functions. And when it happens that way, then the public is able to follow what Parliament does and even hold their members accountable whether they are serving their interests or not. So that is a beautiful thing. So let me take you through now my prepared slide and to put it in perspective. Okay, so what is the constitutional basis for practice and procedure? I've given you that Article 110 of the Constitution in particular, empowers Parliament to regulate its own proceedings. Okay, regulate to how it does its things. But we should take cognizance. That's why the provision empowering Parliament to adopt its own procedure start with subject to the provisions of the Constitution. So it means that in all cases where the Constitution has given a procedure or a step to follow, then that becomes your number one before you can build upon it. So you pick the standing orders of Parliament. You must see three implied things. Okay. First, about powers of Parliament. Two, you must see the procedure from the Constitution. So you see that sometimes there's a lifting or provision of the straight from the Constitution and the position in the standing orders. You see that one there. And you may see an extension of the rules. Okay, extension of the rules. So all those matters are put in there to ensure that Parliament will be very effective in doing or performing its constitutional duties. So, as I said, pursuant to Article 110 of the Constitution, Parliament has adopted a new constitution. You know about that in January 2024, but before that, we had one. I think that was adopted in 2012 or 2010. I'm not quite sure about that. Okay, so these ones definitely regulate or governs how Parliament engages in debate, the language to use. You have unparliamentary language where members, maybe in the course of debate, say they say something that is against the practice of the House or the rules of decorum in the House. A member may raise it, and you have to retract and apologize. In some cases, a member can even move a motion that what has been said should be expunged from the records, and the Speaker will make that determination and so direct. So the rules of conduct, motion, everything that Parliament does, including even matters of discipline, are all achieved through practice and procedure, which the main component is the standing orders of the House. Okay, so generally that is parliamentary language, and then the definition we started with, and then practice and procedure, the constitutional basis. Why? And then even the most important part why do we have practice and procedure? Why just Parliament can just every day decide that this is the way we do things? This one, it lacks certainty, predictability. There should be a predictable way to expect that things done this way. And that's why the Constitution, when it comes to even the judiciary, you have rules of court committees setting out the rules or the rules of procedure for the courts, for all the courts. You have the CR 47, which is the most popular for the High Court. And then you have even for the District Court, and then Court of Appeal and the Supreme Court differently. So rules and procedure quite so that you can predict that, oh, if you have a matter before the court, or a matter has been brought against you, these are the steps that, or these are the things that should be expected. And so you should expect that, and through that you're able to prepare and defend yourself and put in everything. So fantastic concept. You can't do anything about it. You just have to study, be keen, try it over time, and you master it. Okay. Yes, so let me take you a little back and then tell you about parliamentary language again, particularly talking about the book that has recently been launched by the speaker himself, Parliamentary Language in Ghana, the Citizen's Guide. It's for the citizens, but most of we, the actors, we don't know them. Sometimes we don't know them very well, but most importantly, we don't understand what they are, what they represent. And so that is why getting to understand it, knowing the context within which it's used, and knowing or having examples to guide you quite crucial. And that is how parliamentary language is done. So it's done to make parliamentary proceedings quite understandable, accessible, and meaningful to the ordinary Ghanaian, while promoting accurate usage, constitutional literacy, and respectful constitutional engagement. Parliament engages in productive discourse, not one that will lead to disorder and all that. Because it's through such a scheme that the truth emerges, quality options come up, even if they are not taken today, tomorrow they may be taken. So that is why Parliament is a house of records. Everything that is said there, you have the official report, detailing, verbatim, largely everything that took place, recording everything there. So to benefit from tomorrow's use. So in essence, my book on parliamentary language, tries to bridge the gap between Parliament and the public. Parliament works for the people directly. Parliament has the most extensive representation, 276 constituencies, or electoral districts have a representative here doing things for and on their behalf. So definitely the people must understand the language which you use so that they can better hold you accountable. Okay. And then it will help us also correct some common misconceptions and misused parliamentary expression. I talked about the yeah, which is incorrect form of the here principle. Try explains parliamentary terms within their constitutional and procedural context with examples, and ultimately will empower citizens to follow, interpret, and participate more intelligently in parliamentary discourse. Okay, so let's go back to practice and procedure. But here I will start with bills and end with subsidiary legislation. Because bills, that is of recent memory, so you will better appreciate it. Okay, so in Parliament of Ghana, there are two main bills that can be introduced. We have the government bills, and then we have private members bills. Okay. The difference or significance in the difference is just the power to initiate. Who can initiate it? If it's initiated by the president, or it's introduced by the sector ministers on behalf of the president, that makes it a government bill. Okay. But if you look at Article 93, and all the other relevant provisions, clearly Parliament has the power to make laws. Yes, when you read through the Constitution, it does not expressly confer the power on a member of Parliament to introduce a bill, but it's implied. That is why you go to Article 108. It tells you that if the bill is not introduced by the president, then it cannot have financial consequences or have financial implications, or you impose a burden on the consolidated fund or other funds of Ghana. Okay, so more or less, if it's a financial bill, it's only the government that can introduce it. So that tells you that then it's trying to limit the bills that members can introduce. So clearly, indirectly, is there. But in some countries, they expressly put it there and confer that right. Okay, so irrespective of the source or the initiating point, whether from the government side or from a member of parliament or even a committee of parliament, a bill must be presented to parliament. So the process is what I'm recounting. So you have presentation and first reading. Before that is done, every document intended for parliamentary action must be submitted to Parliament. I mean, the President of Parliament through the office of the clerk. Okay, in conjunction with the table office. That is the receiving point for all documents intended for Parliament's action. Okay, so of course, when it's received, the clerk brings that to the attention of the business committee that is in charge of arranging the businesses of the House, so that it can be arranged for it to be dealt with on a particular day. Okay, so let's assume that a bill, the Youth Parliament bill, has been received in Parliament, the attention of the business committee drawn to that. The business committee has scheduled it to be laid today. So today it has to be presented. The presentation is used, interchangeably with laying of the bill. And laying of the bill is an introduction of a document in Parliament, because you can't just take something and put in Parliament and say the paper has been laid. There's a procedure, of course. So once is put in the order paper, and then the speaker mentions that item, and the member or the minister who is the sponsor of the bill, in our standing orders, that is the description for the initiator of the bill, the sponsor of the bill. Well, somebody told me that doesn't mean that that person is the one going to pay money before his father. Saying no, the sponsor means that he is the lead person leading the bill and has to, undertake certain functions in Parliament. One of it is you appearing in Parliament to lay the bill, formally say that this is a bill that I am bringing before the House. So, House at a sitting, and then when the speaker calls for the item and is, mentioned, the minister, the sponsor, being a minister or a member, will rise in his place and bow. And I'm sure that is exactly what you guys have been doing, which is positive. And then after the bowing, signifying the laying, then the clerks at the table, or any of the clerks at the table, will be directed to read the long title of the bill. The long title of the bill, I hope, yes, as for Mr. Speaker, you know about that, but I hope your members know about the short title of a bill and the long title. The short title is the name, the label. Let me see. Yeah. Okay, so this is the Land Act. I don't know if you can see it. So the Land Act, this is the short title. That's the name of the law. That's how we call it. So if it's a bill, it would have been the Land Bill 2020. Okay, so that would be the short title. And then you go into the bill. We assuming that there's a bill. You have this one wouldn't have been an act, but it would have been, let's say, a bill to do ABC. So the long title is this, which is a summary of the provisions, more or less, it gives a best view of whatever is contained in the law. That is when we say reading of a bill, that is what is read. It's not the entirety of the bill, but the concept expresses that it's the entirety of the bill that must be read. But practicability and time, prudence will not allow that to be done. That is why the summary of the law or the proposed law is read to signify the reading of the bill. So when that is done, the whole bill is taken to have been read and physically opening from page to page and reading it. So when we say reading the bill, it is the long title that is read and that is treated as the reading of the bill. So that when we say reading of a bill, that's what it means. It doesn't mean that we're reading from cover to cover because time will not permit that and everybody has a copy. Ghanaians, even through certain schemes, will have copies. So you don't need to waste time and do that. So what you do is that the long title is read to signify that process. So you have first, presentation and first reading stage done. As soon as this stage is done, or consequent to this stage, then the speaker will refer it to the appropriate committee, the committee that has jurisdiction in connection with the subject matter of the bill. So this bill that is Land Act or Land Bill was referred to the Committee on Lands and Natural Resources. Those days, it was called Committee on Lands and Forestry, if you remember. But now it's Committee on Lands and Natural Resources. So the solid minerals have been added to the mandate of this committee. And of course, natural resources also include our forest resources, wildlife, and the rest of them. Okay, so you have presentation and first reading, and at the same stage where the bill is referred to the appropriate committee for consideration. So here, in your case, I was told that, the matter was considered by the committee of the whole. The committee of the whole is just like one of the committees of the House. It's just the membership that is extended to everyone, but it's a committee. So when the House is sitting, the House will have to suspend that sitting and reconstitute itself into committee of the whole, because the procedures are quite different. The procedures at committee are less relaxed, and you have a chairman and not the speaker. The speaker will not be sitting as the speaker, but as the chairman. And then the speaker may even delegate that, presiding function to maybe any of the deputies or whatever, or the most senior even member to even chair. And so when the business for the committee of the whole is done, then you reconstitute and come back to the normal sitting and continue the process. So here, where we have standing and select committees already done in place, then you refer it to the committee. So now you have the committee stage. You can describe that one as the next stage or stage 2, the committee stage. Okay, so at the committee stage, that is where the committee is given the mandate, okay, or the assignment to go and scrutinize the bill and report. So for consideration and report to the House. So the committee, as part of its processes and practices and all that. So when we're talking about parliamentary practice and procedure, it's not only for the plenary, but any subdivision of parliament, including committees, is also applicable. So the committee, in a more practical terms, will have to engage stakeholders, will have to publish to receive comments or what we call written memoranda, views, comments from the public. And sometimes we even hold stakeholder forum or platforms where people can come and speak to what they have read in the committees or even make oral presentations. And of course, afterwards, they have to reduce them into writing and submit to the committee, so that later when the committee sits to consider the bill clause by clause, the committee would have had its view, may have the view of the public or stakeholders, and incorporate or factor all those things when it's doing the consideration or its scrutiny or examination of the bill. So at the end of the committee's work, the committee will submit a report. So this report is signed by the chairman and the clerk to the committee and laid in the house. So of course, the when it's ready, the business committee's attention will be drawn, and it will be so scheduled. So, but it will stand in the name of the chairman of the committee, and it will be laid. So the report on the bill will be laid and distributed to the members. Okay, so it means that the third stage, it's not in any description, but we are talking about steps. Okay, so the third step here will be the second reading. Okay, so committee, so the bill was presented, laid in the house, and then read the first and referred to the appropriate committee for consideration and report. The committee has duly considered the bill, scrutinized it, consulted, and done everything. And then what it thinks about the bill, it will report that to the House. And this report is distributed to members. So that paves the way for a motion to be moved by the sponsor for the second reading of the bill. Just as the way the first reading was done, the same way, but following the motion, the debate, the chairman of the committee will be the one to second the motion for second reading. And in seconding the motion, will now present the committee report. So the committee report will, because members have copies, they are not read verbatim. Okay, so the speaker, so the chairman may make the appeal that, to the Hansard or the official reporting department to capture the bill as having been read and highlight some few portions of it. Okay, so that the motion for second reading having been moved and seconded by the chair who has presented the committee report, then the debate on the principles, the pros and cons of the bill will take place. So here we are dealing with the principles. What is this bill coming to do? Do we even need it at all? If you remember the second debate on the human sexual rights and Ghanaian family values bill, it was a tense one, debating as to whether the law should even be used to be that intrusive into the private affairs of people. Some will say that yes, if we need to preserve the values as a group of people, then we should be so interested. That kind of debate, that is on the principle. Here, we have not moved to the content of the bill. We are dealing with the surface, the generality of it. This thing, is it good at all to proceed on? What is it coming to do? Don't we have any existing law to deal with that and all that? Okay. Whether it's even constitutional to do such a thing or not, they will all come to the fore, and debate will do that. So at the end of debate, the question will be put. And when we say question being put, that means that is decision time. There will be a voting. So if that motion is carried on, the majority supports that, then we'll go to the next stage, which is the consideration stage. So this is having agreed on the principle that the bill is okay, it's a good step to move, then, or a good step to take. Then now we want to ensure we now come to the detail, every clause, come and debate every clause and vote on every clause. Just that, so when every clause is called, and then the speaker will ask whether there are any, proposed amendments. Sometimes some of the proposed amendments are advertised, so members will have full knowledge of it and prepare either to support or to, disagree with that. But if there's none, the speaker will still ask whether there are any proposed amendments. If there are no proposed amendments, the speaker may put the question, because it has to be voted upon. But if the speaker realizes that maybe for about 10 clauses, a bill, the provision of provisions in a bill are called clauses. and sub-clauses. Okay, so when it comes over, you take every clause as a whole, so one clause at a time. He realized that there are no advertised amendments or a number of them. He can put all of them together and call for the vote, or put the question on all of them, maybe clauses 1 to 30. If he says that there's no amendment, then we say that, those who are in favor that clauses 1 to 30 should be made to stand part of the bill, say aye. Those against, so no. And then if it's carried, then it will be agreed to, they move to the next one. But where the advertised amendment, or even members are allowed to make extempo amendment or propose extempo amendments, then it will be debated. And if it's agreed to, it's adopted. If it's agreed to, then it's rejected. Okay, so that will be done till the end of it. It is at the end of the bill that now they revert to the long title, because you will see that sometimes there may be some amendments that will vary the summary that was given. You might have to introduce something or take something out. So that one would also be considered, and where amendments are proposed, that will be adopted or maybe rejected. And then that's the last thing that is done. It's just like you are writing your abstract of your thesis or maybe a term paper. Of course, you have to finish the whole work before you can give that quick summary. Okay, so that will be done. Okay, and so this one, so when the long title is also, a question is put on that and agreed to, that ends the consideration stage. So then at this stage, the office that I head now, the legislation office, has a number of rules to perform throughout all these processes that we have done. I don't have the time to bore you with that. But at this stage, what the new standing orders require is that my office will incorporate the amendments that Parliament has made in the course of the consideration stage, so that there will be more or less an amended version of the bill, to prepare it so that copies will be given to members to see the latest version of the bill, so that in cases where the consideration has taken a very long period, members would have even forgotten about some of the changes that were made at different points. The members will have a second opportunity to look at the new version of the bill and see if there's a need. There's a need to, move for second consideration or take any other step. Okay, so so now when that is done, it will, at the end of the consideration stage, then the opportunity or the way is paid for the third reading, which is the final reading. I remember that the third reading is a procedural step, just for Parliament to hit the gavel on it and say that this process is completed. But it has some significance, because before that motion is moved, or when the motion is moved, then a member can arrest the motion and then move that the bill be taken through a second consideration stage, or further consideration, so that if some other matters have been wrongly captured, or there's a need to strengthen some other provision, that opportunity will be had. Okay, so if that is not done, then the motion for third reading, which is the final one, will be moved by the sponsor, of course, at this stage too. And then there won't be any debate, because that's why I said it's procedural, just the procedure requiring that. But because there's an opportunity to arrest and move for further consideration, that is why it's there. And then that signifies the passing of a bill by Parliament. At that stage, it's still a bill. So my office, what we do is that now, when the process ends or Parliament passes a bill, then we'll put it in a form. There are some conventional things that we do, and then we'll seek the permission of the clerk to get it printed on a vellum paper. Vellum paper is a more durable and more quality sheets that is printed on. We do about 8 copies, which by the Interpretation Act or by law, it's supposed to submit the original acts when they are signed into law, or when they become an act, sent to certain offices, including the office of the president, the speaker, the chief justice, and the rest of them. So when we have incorporated all the amendments and it's printed on the vellum paper, that gives us the original copy of the bill as passed by Parliament. So if it's ordinary bill, a bill other than a financial bill or money bills as called in some jurisdiction, then the clerk to Parliament will authenticate. The clerk to Parliament is the scribe for Parliament. Okay, so official matters or document going from Parliament should be signed by him. So out of that mandate, he authenticates or tells you that this is the original or the right copy that Parliament has passed. So he will make that authentication, a proof that has been that is the right copy of it, and then we'll send it. There will be a portion for the president. So it will be a letter will be put on it requesting the invitation or inviting the president or informing the secretary to the president to invite the president to assent to the bill. But of course, that will be the tenure of it. But the invitation to assent means that he can also refuse to assent, and of course he has it's available to him all the procedure, the constitutional options that he can employ. But when the president assents to it, then it becomes an act of Parliament. So the original copy is obtained. The seal of the president or the presidential stamp is not kept at the Flagstaff House. So you have to go to the National Investigations Bureau, NIB, for embossment of the presidential seal, and that gives you. And then when we come back, we give it an act number, which is done serially. So now you come to my office, we have a list of, let's say, all the recent acts that have been passed, and there, so we know that the next one will follow. If I can see well, it's 1151 that we have, so the next one will be 1152. That's how, just continuing the counting, and then we'll put that. So that becomes the original copy of the act, the new act. So that is not the ones you buy from Assembly Press and elsewhere. And what is printed is not the original. Hello? It's not the original.
We are keenly following, sir. We are keenly following.
Great. Thank you for that. Yeah, so when we have the original copy of the act, the new act, and we have added or endorsed the new act number or the act number, every act of Parliament has a number. That's why when you see this one, this is the one that will be printed for the general public. This is not the original copy. So you see that you have Act 1036. That becomes the alternative or the short form that you can refer to. By any time you are writing the law, you write it in full, Land Act 2020 Act 1036, so that in subsequent reference to the same act, you can say Act 32, and then it's referable. Okay. So when that is done, then we write to Assembly Press that this law has been passed, duly assented to by the president, and so the Constitution requires that it must be gazetted again. Possibly, I skipped that point when we said that the law requires that before you introduce the bill, ordinary bill in Parliament, you must gazette for 14 days before you introduce it, unless it's treated under certificate of urgency. I don't want to confuse you with that. So we can have another session where we can do more detailed discussion about all the nuances there. But when you are introducing it ordinarily, you must gazette it. Then when it has been passed by Parliament, assented to by the president, processed, and it's ready, the new law must also be gazetted. And I have an article and a couple of articles relating to Parliament that I will share with your speaker so that can be shared with you. I've written, I write a lot with one mentee, Goodnav Labi. No, good luck, Jonathan. So we have questioned ourselves, what's even the relevance of the publication of bills in the Gazette? Because I'm sure, Mr. Speaker, have you seen a copy of the Gazette before? The Ghana Gazette, have you seen a copy before?
I wouldn't say not well, but I think so.
But maybe you got it maybe when you were doing other transactions like change of name and other matters, and not because you wanted to see one.
Exactly.
So it means that that's an obscure constitutional document. It's supposed to be the reference point for me communicating to the public. And it has even for a law, so a matter even goes to a court and you are telling the court that a certain law exists. The proof is traceable to the Gazette. It's a very important instrument and has even more functions. But it will surprise you to note that it's even just the law, the short title that is stated in the Gazette. So what is to inform the public? It has no information. So when the Supreme Court in which case, in the case that Section 43 of the Narcotic Control Commission Act was challenged, the Parliament inserted the power to to be given to the Minister for Interior to authorize the growing of marijuana for medicinal purpose. Somebody challenges, I think that is Manan versus Attorney General, that Parliament, acted in excess of its powers when it inserted that provision, because that was a dramatic change in events. The country had never allowed that to be done, and that was the first time. So it was a drastic policy change. And so it would have been proper, or per Article 106 of the Constitution, it should have been in the explanatory memorandum before Parliament could have done that. And I've written to question that decision, though the Parliament acted right. But when the Supreme Court annulled Section 43, but luckily Parliament did the needful by going through that process again and amended that provision. So it's now still a good law or a good power for the Minister for Interior to grant the power for cultivation of marijuana for medicinal purposes. Okay.
And also, sir, the issue about Gazette, I've also been following the Parliament of Kenya, and I realized that very important sittings of the Parliament of Kenya are being gazetted. For instance, removal of office by impeachment of a governor or deputy governor, it usually comes to the Senate, and they gazette it. They gazette the date for the sitting, but I scarcely see such notices from Parliament of Ghana. Yes.
Yes, so we don't have that, but it's all because so maybe that remedy is Parliament also recording these things, because when it comes to the Gazette, it's for legal proofs, whether you can use it as evidence in court. Okay, but if parliamentary record is kept in a formalized way and can be used in court, then that becomes an alternative. But the point is that now even the Gazette, which is supposed to inform the people, in a more effective way, that is not what is happening, because even you ask law students and they have never seen the Gazette. As who are married that went through, that process. If not, they have not seen Gazette. They don't know how it looks like. So if lawyers, law students, they have not even seen Gazette before, and then we put emphasis on that, then we are just acting for no value. Okay. So yes, so different countries and how they have built their systems. But so in that article that I'm talking about, we called for more work to be done. So we even went back to even tease that decision of the Supreme Court, that so when the Supreme Court was saying that the people should be informed before Parliament could do that. It was the long title that would have been published. So there was no value that could have been added to that decision of the Supreme Court at all. Because in any case, it's just the long title, and the long title will not show which session was, coming up, But if the whole thing is published, then it's made accessible. I'm not sure that you walk to even any news vendor point or a newspaper vendor point, you can get a copy of the Gazette. You can get.
Mm-hmm.
You see, so it's not accessible. That's why Parliament has built its own system. So because the Assembly Press, the Assembly Press, the name Assembly was because we started calling ourselves National Assembly. So it was Parliament Press. Then for some reason, the executive took over and sent it under the authority or umbrella of the Attorney General. And that's how come that difficulty is there. So now Parliament seeing the difficulty created by them, Parliament now within 7 days, when a bill is laid in Parliament, within 7 days, my office will ensure that it's published on Parliament website. The full text is published on Parliament website, and people have free access to it. So you can make use of that too. So you go to Parliament website now, you have copies of all the bills that have been laid, but that should be credited to Honorable Alban Sumana Kingsford Bagwin. And that is the value you get when you are very experienced hand in the House, because he has lived it all, knows it all, has experienced all the external environments, and then opted for that. So that has become a very good cushioning. So for Shege reasons, any bill that comes, you go and download it and have it there, because we have another difficulty with the Assembly Press. When they print the final copy of a new law, they omit the explanatory memorandum. And the explanatory memorandum has high educational value, because that will tell you about what gave birth to the law. So even when it comes to interpretation, trying to discover the meaning, the proper meaning of ambiguous or unclear terms in the law, it is that side that you refer to. Okay. So for educational purpose, you need the explanatory memorandum. But when you have a copy of the bill, likely it comes with the explanatory memorandum. So you always have it. So the scan copy is always available on Parliament website. So that can be explored. So quickly, let me take just about 5 minutes to deal with subsidiary legislation. Okay. And that is where I have also another recent book there that I recommend strongly for every honorable member on this platform, and then all your branches or your colleagues elsewhere. And the same concept can be replicated even in other countries. And then if some funding can be secured, that I can even also assist in consulting for that. Okay, so having seen or the elaborate process, or you pick Article 106 to Article 108, Article 107 talking about, Parliament cannot pass a law to change the decision of a court. Okay, and then you cannot also make retrospective legislation or making a law to impose a burden or some liability on persons for their past actions. Okay, definitely that is not allowed. But at the actual process, the power to make laws, generally flowing from Article 93.2 and then 106.1. Okay, and then the Constitution giving the procedure, and Parliament has built into that procedure. Like I said, the constitutional procedure is adopted hook, line, and sinker, and then other parts are joined in by Parliament to strengthen that. And that is why the standing orders is there. But even beyond the standing orders, we've seen that present procedure go beyond what is written. There are other practices that also inform how Parliament do what it does. Okay. So you have that. So quickly we go to subsidiary legislation. So what is subsidiary legislation? It's a broader term, or it's a generic term for constitutional instruments, legislative instruments, executive instruments, bylaws, directions, and all those kind of laws that are made by way of delegated lawmaking powers. So the Constitution, I always cite Article 52 of the Constitution, where the Electoral Commission, having been given the power to conduct elections and prepare electoral roll and the rest of them, is given the power to exercise its powers by way of a constitutional instrument. Okay, so this one is not Parliament that has delegated the power. Parliament is the supreme lawmaking body, not sovereign though, but that's the main body. But the Constitution sometimes will take that power and give to another body. An example is what I've shown you. And when you look at my book, all the delegated powers under the Constitution have been set out there for you. And then you see and which ones will even require to be laid in Parliament and all that. But let's go through the process. So you see that the process I've given to you is quite elaborate. But when it comes to subsidiary legislation, it's controlled by Article 11(7) of the Constitution. And the process is just as short as that. It must be laid in Parliament, gazetted the same day it is laid in Parliament, and then it has to remain in Parliament for 21 sitting days of Parliament. Remember, it's a sitting day. So you don't just lay it, and if Parliament is not sitting, you just continue to count days. It's only the days that Parliament sits that you count. So when it's laid, it's gazetted the same day it's laid, and upon the expiry 1 days of Parliament, automatically it becomes law. So if Parliament doesn't do anything, it becomes law, and that's what we call negative resolution. Some countries, they have the positive and the negative resolution. Positive resolution is where Parliament must vote to approve it or disapprove it. But this one, Parliament may choose not to do anything. That is why sometimes you see that the Committee on Subsidiary Legislation will report, Parliament will adopt the report before the law, or maybe it will be left with maybe 5 days to achieve the 21 sitting days. But when the Parliament adopts the report, then the misinformation goes out there that Parliament has passed or approved that regulation, because they don't have this understanding. Okay, it means that what can be passed also within a short time can also be passed over a long time. Now, Parliament goes on the longest recess during the summer, so maybe July to about September, October is recess. So just imagine that if it was late 10 days and the Parliament went on recess, Parliament will have to come after 3 months before the counting continues. So when you also see that, don't say there's something wrong, because it's the sitting day. The rule is about the days that Parliament sits and none other. Okay, so then you do it. So you see that one, you just lay it in Parliament, and then you gazette it the same day, and then upon 21 sitting days of Parliament, then it becomes law. So the 21 sitting days, the essence is that why 21 sitting days? The 21 sitting days is to give the opportunity for members so that on 21 times, they will have the opportunity to acknowledge if they find something wrong with it. And that is through the annulment procedure, which is the only way Parliament can act against regulation that is laid before it. Okay, so that brings me to the end for one of time of our discussion. And so now we'll open up for questions. I'm sure you will have so many questions for me. So if you're unable to end another time, you can just invite me, and I'm always willing. Mr. Speaker was even saying that, oh, it's a Christmas gift. My love for the youth, but the last time I met you, I think I shared that. When I see the youth trying to do something positive as this, if I have the resources, I will even use my resources to support. Okay, so I wouldn't take anything from it as an opportunity when we are grown, and then you are the future leaders, or Speaker will say you are the current leaders, okay, or tomorrow leaders. If we have not groomed you well, you will come and give us bad governance, and all our toil would have ended. So it is the basis, the duty of everyone to make sure that we owe it as a duty to support you to grow. So if you have come out with this brilliant idea to organize yourselves and to empower yourself, so be it. You don't even have to end up becoming a member of parliament or a speaker or minister or whatever. But wherever you find yourself, that leadership skills, experience you have can help you to, do far better. So anytime you need me, especially after working hours, I am there to share the little knowledge that I have. So, and I recommend that you get these two books, the one on subsidiary legislation and the parliamentary language. Parliamentary language is 200 Ghana cedis. Subsidiary legislation goes for 300. So together they are they got 500 Ghana cedis. If you're in Accra, there will be free delivery. You don't have to worry, or Mr. Speaker can make an arrangement to gather them for you. Get them, know more about Parliament. The difficulty is that you don't have a lot of documents, literary work on Parliament, and that is not good enough. There are a number of other writings that I'm doing, all to support this process. For Parliament, people to have something to read about Parliament and to understand Parliament and hold Parliament appropriately accountable. If not, we'll be holding members of Parliament for not constructing roads when it's not their duty to construct roads. But they have the duty to bring that difficulty to the attention of government and hold them. But when people say we will lobby, you will lobby who? Will you want to be in opposition and lobby the government of the day to go and find money that is not available to go and do your road? And so if lobbying is any productive option, then why is it so for 276 members of parliament, everybody will go and say, I'm lobbying and your road will be done? No. So if you give a professor of maybe engineering a first year law student question, he will fail, or you are giving a wrong paper. So it's good that we identify the paper that must be given to our people so that we can appropriately assess. Thank you very much, and I'm your hands, Mr. Speaker.
Wow, sir. Thank you so much for this impactful presentation you have done. I must say, Youth Impact Parliament and Movement is so grateful for this time you have given. And
Almost grateful for the opportunity too.
I'm literally short of words, but we are hungry to learn more from you, sir. We are
So
hungry to learn more.
anytime, and it shouldn't be just today.
Yeah.
Anytime you want me to, you're having your program, but you can engage me virtually like this.
Yes, sir.
And then if I have a word to share with you, just some few minutes, I would love to be part of that productive group. Yes.
Yes, sir. So thank you so much. So we'll go straight to the question. I have some questions as well, but let me open the floor for my colleagues to ask their questions first. So colleagues, the floor is now open for questions you have to Mr. Benjamin Tachie Antiedu. Antiedu. Thank you.
Yes.
Mr. Benjamin Tachie Antiedu Esq, who is a legal author of 2 important books, totaling 500.
So I have even 3 books, one on reading the law, but that one, except for those who are interested in reading law, the whole country, that is the book that guides you to study law and to study it effectively and, seamlessly, so that you go through without much difficulty. And it's been adopted by University of Ghana, a whole lot of other law faculties, and even internationally. International Law Institute has adopted it into their library, and it's doing so well in Ghana and beyond.
Wow. Nice. So we, the ones who are interested in becoming lawyers, including me, will get that book when it is time.
It's automatic. So if you bring me about 10,000 Ghana cedis, you have a book that I have, including the future ones.
Nice.
That's on the lighter side.
Nice. Yes, and also the Director of Legislation at Parliament of the Republic of Ghana. Honourable members, any questions, please raise your hands and I'll call you to ask your questions. Any questions? Okay, Honorable Collins.
Good evening.
Good
Thank you,
evening,
sir,
my
for the
brother.
education.
Most welcome.
Thank you for the education.
You are welcome, brother.
Please, I would like to know more about the laying of the individual bill. How is it laid? Then who can
Laying
lay
of
the
laying of who?
individual
What?
bills?
Okay. And who lays it?
Yes,
Okay.
yes, please. Can anyone send a bill to Parliament? Thank you.
Okay. You're welcome, brother. I get your question.
Okay, thank you very much, Collins. Colleagues, any other questions? I can see Edward. Yes, Adam. Adam Osman is our Speaker of Parliament. Adam,
Oh,
I want to
wonderful.
hear your questions. Yes.
Okay.
He was also
So I
at the
was just
PN
telling
Africa conference that you spoke at. He was also there.
okay, great.
Yeah,
Great.
yes.
Great.
Yes, Adam.
Good evening, House. Good evening,
evening.
Mr. Benjamin.
Good evening, my brother. Or
That
honorable
was
member.
a very, very wonderful presentation.
Thank you, my
Um,
brother.
Even though I know some of them, but I've learned a lot and I've added to my depth of knowledge.
That's nice to know.
So my simple question is, the gazette that is being released every day by the Ghana Publishing Company.
Yes.
Can you at any time get the gazette for previous like for the previous months?
Okay.
And with that, does it come at a fee?
Okay. Yes, your question is well captured.
Okay. Thank you very much, Mr. Speaker, for your questions. Honourable members, any other questions?
Gente, aqui quer entrega de cesta básica.
I think some of our colleagues from India are also part. I can see here, they don't look like Indian name, but that sounds like an India ancestor. Yeah. We also have a chapter in India, though.
Wonderful.
Let me go ahead with my questions so that you address all of them at once.
Sure.
The first question I have is how appropriation bills are passed, whether they are as elaborate as I think I'll mute them. I'll mute them. Yes, so yes, I was asking if
how appropriation bills are passed, right?
Yes, if they are also as elaborate as the normal bills. And then the second question is the preliminary objections. How exactly they are handled?
Please come again. The preliminary what?
How the preliminary objections in Parliament are handled, and why exactly are they relevant for MPs to lay preliminary objections?
Okay.
And the third one is does your department handle draft all private members' bills that are passed in Parliament?
Oh, okay.
So these are my questions.
Okay, wonderful. So maybe this one, maybe take this one before we may move to the next one. So the first question from my brother is, how is laying or how can an individual MP lay a bill, or how is a bill laid in Parliament and who lays it? Okay. So yes, we're saying that a bill is laid or presented to Parliament by the sponsor, the one who is sponsoring it. So if it's a minister who introduced the bill as a government bill, then it is that minister that will lay it. Sometimes the minister may not be available, and then some delegation or maybe some other person might be allowed to lay it. Okay, particularly another member of minister will be allowed to lay it, or the deputy minister may be allowed to lay it in Parliament. Okay, yes, but if you recall, laying of a bill in Parliament entails the sponsor rising in his place, Okay, when the item is called, he will rise and bow, and then the clerk at the table will read aloud the long title of the bill. So that is how a bill is laid in Parliament. For the laying of any other document, is the same thing. The title of that document will be read after the rising and bowing. Okay, so that is how you signify or you show that the document has been properly put before the House will have jurisdiction to deal with it. Good. So the next question is on Ghana Gazette, whether you can get all previous Gazette to buy, or you can procure that, and whether you must pay money to do so. Yes, you can buy. They are available there. You buy at a cost, Assembly Press, and I'm tempted to believe that they will have copies for whatever year you may be interested in once it has taken place or it has been produced. Okay, so you can get some to buy. I'm sure that if they don't even have it readily, they can print it for you. So you can get them. Then we move to President questions. Question 1. How are appropriation bills passed? Are they passed in accordance with the same bill procedure, or there's a special procedure for it? That's how I understood that. And so for that is the same procedure. It's just the purpose is for appropriation of public funds, how public funds can be used. That is all. There's only special thing about it, but it goes through the same process. So you have the presentation and first reading. Definitely that will be done by the Minister for Finance, who is the automatic sponsor of the appropriation bill. And then, of course, there will be a referral from the Speaker to the appropriate committee here, possibly the Finance Committee. Or now we have the Committee on Economy and Development. I don't particularly know whether they have that mandate or the budgets or committee. But the appropriate committee will deal with it and report to the House. But you see that it's a very simplified bill because it's capturing the total amount that has been approved by the House, and then the various sector totals too will appear. And so during the consideration stage, if there's any mistake or whatever, that will be corrected. Okay, but it's not done as and then it will have some few clauses. So generally the consideration stage is done to clean it up, not to make any, because they are not making rules. It's just that you are making a law that gives authority from Parliament to enable the government to spend the money as approved by Parliament. So that's satisfying the constitutional, authority under Article 179 of the Constitution. That is the whole essence of it. So, they're just about two. So it's just about two provisions, two clauses with the table, giving the breakdown of the total sum that has been approved. So, but it goes through the same process, going through first reading, second reading, consideration stage, and third reading, and having been passed, and then printing on vellum paper. I mean, those ones are outside parliamentary work, but I'm just bringing that one as a recap. And then you are transmitting same to the president for assent, and then we'll continue with endorsement and giving numbers and all that. So the same procedure, just that the intention for consideration is just to correct errors. Okay,
I
so
have a follow-up question on that one before we move to the next one.
okay.
So with that, I see that it seems they passed the appropriation bills very quickly. And is it like they pass all of them under certificate of urgency?
So yes. So that brings in a very important aspect. Even today, I had to advise on one of them. The Constitution, that the requirement for 14-day prior Gazette notification is not applicable to financial bills. So clearly, appropriation bill is a financial bill. Okay, so that one, you don't need to even introduce it under certificate of urgency. It's allowed that Parliament can just pass it without any limitation of time or restricting some time to pass before you do that. So it's an automatic right to deal with financial bills without even getting a committee to determine or to make the decision as to whether it's urgent and should be treated under certificate of urgency. The certificate of urgency thing, the only waiver is that you don't go and gazette it and wait for 14 days before you bring it to Parliament. That is the only thing. But the rest of the processes will happen. And in Parliament, it's just about suspending the orders that are not constitutional, that are not constitutional, so that you can pass
sorry.
them.
Can you hear me? Can you hear me?
Okay. Yes, I can hear you.
Yes. Can you speak a little slowly because my English is not that good?
You are not hearing me. I'm sorry.
Can you speak a little slowly? I'm a professor.
Can I speak slowly? Oh, sorry. Then I've caused a lot of damage. I'm very, very sorry. Hello.
Hello.
So please, I will relax. I will speak slowly. Thank you, bro. Thank you. So I made a point that money bills or bills that are dealing with money issues, money funds, public funds, they are granted automatic expedited processing by Parliament or approval by Parliament. So you don't have to gazette them and wait for 14 days before you bring them to Parliament. You can lay them through Parliament through the same process, and then Parliament, if leadership agrees to that, then they will take them through the processes in a day or in a fast form, because the process is just procedural in nature. Because I'm saying that is only bills are given that elaborate procedure, so that what becomes law is highly scrutinized before it comes out. But this one, Parliament has already approved the economic policy of the government, and then gone ahead to approve every head of estimate. So it just to put it in a legal form, give an authority in a legal form. So the decision has been taken already. You are just, giving a legal authority for the president to spend. That is why it passes like a speed of wind, because there's nothing to, hold, because you are not now going to, raise the point that the money given to, let's say, the Minister for Interior is bigger or smaller. No, the decisions have just been taken, just about a form, giving it a legal taste, giving it a legal authority, because that's what the Constitution requires, that no public fund can be spent unless with the authority of Parliament and an act of Parliament. Okay, so yes. And then you spoke also about preliminary objections. Yes, preliminary objections. So remember that when the nomination of the Chief Justice, the current Chief Justice, was transmitted to Parliament, the minority raised a matter that matter was sub judice, was a matter pending before the court. So Parliament wasn't clothed with the power to proceed. Okay, that's a preliminary objection. So that if the Speaker or the House agree to that, then they will not proceed. So they are quite relevant, so that you stop something that may be unconstitutional. Okay, sorry. So, but for that particular one, I think that Parliament was, right in proceeding, because the concept of sub judice is not a legal rule. It's a self-restraint that Parliament puts upon itself, that when matters are before the court, and then what we're going to do may be prejudicial or will impact on the decision that may come out, then we will respect or we will just restrain ourselves. So it's a self-restraint measure. It's not an imposition on Parliament. The same, there is one principle that operates in this fashion from the judicial end, and that is non-justiciable political question. So that also ensures that when matters go before the court, particularly the Supreme Court, will say that, oh, for this matter is squarely within the mandate of Parliament. So for that reason, we are unable to, assume jurisdiction and deal with it. but it's all a matter of sovereignty. Our Supreme Court has said that every provision of the Constitution is to be given effect to. So they will not even recognize that, American concept of non-justiciable political questions. So it's not an imposition or limitation of Parliament powers, but Parliament can decide at any time to do, because you need to assert your authority first. So what about opening the floodgates so that the mere fact that somebody has gone to court should stay Parliament? Then when budget is going to be raised, somebody will just institute a suit in the Supreme Court, and the Parliament cannot act. That will also mean that your authority is undermined, and if you cannot survive, you can also
Gente, desculpa me incomodar, mas que vídeo é esse do Benjamin?
have the ability to protect the jurisdiction of another organ. Okay, good. So if I may proceed to the last question, that is about whether my office, the legislation office, thank you very much. So the last question is whether the legislation office, which I heard, processes all private members' bills, or also process all private members' bills. As I said, so Parliament, all bills, the office, so we have two different or two similar offices dealing with bills. We have a legislative drafting office. It's also a different department. Then we have the legislation office. So the drafting of legislation is about writing of the proposed law, the bill. Okay, so that one, the writing of it is done by that office. So a private member wants to introduce, or a member of Parliament wants to introduce a private member's bill. There is a process. You apply, it goes to through the clerk to the speaker. If the speaker permits it, then it goes back to the clerk, and then it goes to the legislative drafting office for them to write it out for you, and then it goes back and all that before it is allowed to be laid in the house. Once it's laid in the house, then it becomes our baby, and our baby in the sense that we will spearhead every activity that happens to a bill. For example, before a bill is even laid in Parliament, it is this legislation office that will confer with the Assembly press, to ascertain whether the bill has complied with the 14-day prior notification or publication. Okay, if it's an ordinary bill. So that is number one. And then within 7 days after the bill has been laid, it is this legislation office that will ensure or will liaise with our ICT department to ensure that the text of the bill is published.
Benjamin, it's that someone found out some videos on when where you are advertising exotic things. I don't know.
Yes, apologies. We are having some, should I say, some interruptions from some other people, and I'm going to remove them all from the
That's
call.
understandable. Don't worry.
Yes. Thank you.
This video you appear.
So the private members bill, when it's laid, will be like any other bill that has been laid. As a recounting, we'll first check whether it complies with prior gazette notification, and two, and then within 7 days, we cause that to be published on Parliament website, so that members of the public will have access to the bill while Parliament is considering it. Okay, so that brings to the end of the 5 questions I noted. Yes. So,
Yes.
President, I'm in your hands now.
Yes, thank you very much. I think the presentation has been so good, and then I just hope we can subdue this. I think at this point in time, we'll go ahead and take your closing remarks, and then from there we'll bring the program to a close.
So you want me to give the closing remarks?
Yes.
Okay, wonderful. So just expressing
Maria, o seu
my
tá
delight,
diferente. Quem foi
excitement
que comeu isso?
to share
A
my
sua mãe,
views with
aquelas
you
vagabundas.
on parliamentary language,
Guys, please,
practice
guys,
and
please.
procedure. These are
Let
fundamental
the
things that
Benjamin
equip you
speak.
for the affirmative action. Just bad youth, congratulations on that. But now you have seen the process as you followed. Is what pertains in Parliament, and you try to model everything that is done in Parliament. And then, so I've had exciting questions, very intelligent ones, and we touched on laying of bills and who lays it, and then, availability of Ghana Gazette, and then how you procure one, the matters on how appropriation bills are passed, how preliminary objections are made, and whether they are relevant at all, and how private members' bills are processed and passed in Parliament. So there's an exciting platform for me, an opportunity to engage you, our tomorrow leaders, and then just to commend you that this is a wonderful thing that I pray that you go far and far and far, reach more continents so that together we build a very formidable youth to take over the reins of government tomorrow.
Thank you so much, sir.
Yeah, sure.
On behalf of Youth Impact Movement and myself, I want to say a very big thank you to you, sir, for these clarities you have given and expanded our knowledge. With what we did on Sunday and the additional knowledge you have given us, it looks like we have basically come for a class to be a better member of parliament. And this is so much of I don't even have the words to say, but I'll just say that it is a blessing that you have made time available, because as of now, Parliament of Ghana is still sitting, and I know if not for this seminar, you'll be paying attention there to still continue performing your duties. But however, for giving us time, it just shows the love that you have for us. And I just want to say a very big thank you. But before we give the prayers, may I allow the Speaker of Parliament to just give a short word, and then we go straight to prayers.
for the link. Okay, so first of all, I want to thank the Almighty
Respect
God for
Mr.
a
Benjamin.
successful
We must
virtual
respect
leadership
him.
seminar, and I want to thank Mr. Benjamin for taking time from his busy schedule to educate us on parliamentary language practices and procedures. I'm very happy that during our last sitting, we passed the bill. So I believe the process is very. I believe the procedures are very fresh in the minds of our members. And Mr. Abe, I would just hope and pray that next time when we call on him, he will make time for us to learn as young leaders and upcoming youth to take over the affairs of the country. May God bless us and help us all. Thank you.
Thank you very much. Prof.
Thank you,
Jason.
Thank you.
Yes, Prof. Jason, do you have any remarks for us before we end the session? Prof. Jason from is it UFBA? Okay. If you don't have any remarks, then once again, may I thank Mr. Benjamin for the human job he has done today, for sharing this information with us. Honourable members, just a quick information. Mr. Benjamin has 2 books available for us, one on subsidiary legislation, and then there's another one, and they are going for the cost of 500 cedis in total. So, honourable members, he said he will share his slides as well with us. When he shares it, we'll have an opportunity to look at it. Honourable members, on 26th of December. Yeah, Mr. Speaker.
Jones, before you conclude, I want to ask if we can get a copy of the new standing orders of Parliament.
Yes, it's true. I would ask him. Because it's the old one that we have, and I don't even know whether they have updated their app, because it seems they still have the old one on the Parliament Watch app. So I'll ask him.
App.
Yes. I bet you use that app too.
Yes.
So I'll ask him about it, and if they have also updated the copy over there. Yeah, so we'll be having our 4th annual general meeting on Friday, 26th of December 2025. And I call on members to participate in that annual general meeting. And also, going straight to prayers, let's have a short word of prayer. Father Lord, we thank you for today, as you have been able to help us through a successful 30th edition of the Virtual Leadership Seminar. We call on you to enrich us, and for our future seminars, we call for your control and then guidance for our guest speaker, and also stop the intrusion by unwanted guests. In the name of God the Father, the Son, and the Holy Spirit, thank you. And our members, good night.